Belfast Human Rights Centre session today. I'm delighted to welcome all of you. I understand that we have about 60 guests at this session, hosted by Queen's University in Belfast, and our facilitator, our technical facilitator, is Declan Coy. My thanks to Declan as well. So I'm delighted to welcome as our guest speaker today Lieselotte Viaene. Professor Viaene is based in the social sciences at the University of Carlos III in Madrid. She is currently the principal investigator on the European Research Council funded research project Rivers on water, human rights beyond the human, Indigenous water ontologies, plurilegal encounters, and interlegal translation. I think we could spend half an hour unpacking that, never mind what's in store for us today. With her PhD in law and master's in anthropology, Professor Viaene is ideally placed, I think, to investigate and introduce us to an investigation of a rapidly emerging and very exciting field of legal scholarship and practice, sometimes referred to as the rights of nature. I must say I prefer Lieselotte's language around that. So you're going to the proliferation of attempts to extend the language of rights to the more than human, to nature. And then drawing on her own scholarship and some of her current research, she will talk a little bit about the intersection that this attempt to extend the language of rights to nature, the intersection with Indigenous rights and Indigenous ontologies. We'll talk a little bit more about the ontological turn, implicit for legal practice that arises from this scholarship. And we'll round off with the, I suppose, the inevitable area that this touches on, which is the decolonization, the challenge of decolonizing human rights practices. So I'm delighted to hand over to Lieselotte. I think she'll speak for 25 or 30 minutes. And then I would invite you to indicate if you want to come in with a question, or you may be able to put your question down in the chat function, and I'll mediate and pass on the questions to Lieselotte. So over to you. I'm delighted to see you, and you're very welcome. Thank you.
Thank you, Peter. Thank you very much for this introduction, and also for this very kind invitation to give this online seminar at the Human Rights Centre of Queen's University of Belfast. I hope that at some point soon we can meet in person, and I would love to visit the Northern Ireland. It's already a long time on my top list of travels here in Europe, but I think we all have to. So just to give a bit more of context of this seminar, so Peter and I met, I think more or less a year ago in Germany in a deep dive about ontological issues, politics, ontologies, and so on. And since then, Peter and I have kept in touch, and we had very interesting conversations about transitional justice, because that's actually my first field of research, ontologies, water, nature, indigenous practices, etc. So for me, it's really, I'm really grateful to have this opportunity to have this conversation with my European legal colleagues, because my main experiences are based in Latin America, and that's where my academic community is also based. So as we are still in the first setup phase of the Rivers project, I'm really happy to have this opportunity to have this dialogue, because one of the main goals of this Rivers project, as I will explain is in a minute, but briefly create into dialogues, but also about this very issues. So now I will start sharing my PowerPoint. I hope this works. Okay, seems like. So the title which I choose for this seminar today is Human Rights and the More Than Human, a Legal Anthropological Dialogues. And I have prepared like 5 brief points. The first one is a bit to share a bit with you my own River to the Rivers project. Not so much to tell my life story as such, but as an anthropologist, a very important method or practice that we do is actually the one of self-reflection. And also positioning ourselves in the field that we are working on. And that's very linked with the concept of locus of initiation that scholars like Homi Bhabha from Asia and then Mignolo from Latin America has invited us as researchers to think more critically about what are we talking about or doing our research. Also, as you already noticed, I'm not a native speaker English nor Spanish. I don't have the privilege to work as in my own mother tongue. So I hope that during the seminar I get my points across. Also, I want just to drop that since my childhood I'm stuttering, and even though these days it's not such an issue anymore, but in this kind of seminars you may hear it. And the other point is briefly that I would like to touch is when we think about nature, about humans, and from a law perspective, it seems that we get a kind of a jungle of legal concepts and frameworks. The third point that I would like to share with my thoughts is about what I would call the hype of rights of nature, which Peter already mentioned. And here I use the concept of a nirvana concept, snowballing around the world. A fourth point that I would like to address briefly is if it is actually a good idea to have an indigenous turn in Western law about the conflicts which Peter already mentioned. And then finally, I would like to share some critical thoughts about decolonization of human rights. How we get from the theory to the real practice. So what I'm going to share today is indeed based on the Rivers project, but it's also based on 2 papers that are now in the pipeline, is in English. So it is a bit of combination. It's really good moment for myself to share with you a bit my thoughts, and I'm really looking forward to hear your feedback, to have really a very interesting debate. So my own River to the Rivers project. A lot of people think because of the title Rivers, it's that a project about rights of rivers. Though it's not really the core issue of my project. It's mainly based on my opportunity to collaborate with indigenous peoples in Latin America. And recently I wrote a short blog about the genealogy of the Rivers project, because a lot of people ask me how did I get to that project and those questions. And actually I have to go back quite a long time in time. In 2002, when I was in Guatemala for my master thesis, which was focused on transitional justice in Guatemala, and I was looking into restorative justice and indigenous justice systems and how those systems could support local communities and local processes to deal with the genocide that the indigenous communities suffered. And I remember very, very, very well when I had a conversation with one of the indigenous Maya Kichi widows about what was going on, and she said, for example, that that everything is alive, that the Tzultaka, which you could call from a Western point of view a spiritual reference, which is Tzul is a hill and Taka is a valley, that the Tzultaka, the mountains around the landscape, is actually alive. And back then, I was 22 years old, a Belgian young anthropologist. That was really hard to understand and to get my head around, because for me, mountains were just geological formations, not being alive, just a pile of rocks, and that's it. So that conversation brought a lot of doubts, a lot of challenges in my own thinking, and then I had the opportunity to work more closely from that perspective during my PhD research in Guatemala between 2006 and 2010, where I learned from the Kekchi survivors and also perpetrators of the internal armed conflict of 36 years long, that what happened during the conflict, what we would call from a Western point of view, violations of human rights, was not just limited to the individual and certainly not only to the human. Actually, the Tzultaka, from their perspective, also suffered during the war because of the bombings by the army, because of cutting down the cornfields. In Kekchi ontology's, corn or maize is sacred, it's alive, and it was crying. It was crying when the army burned down the cornfields. And for example, during my research, I worked a lot with indigenous concept, because the majority of the Maya Kekchi survivors don't speak Spanish. So all my research was in the Kekchi language with translators. So I had quite a lot of challenges to translate certain concepts from the transitional justice framework, like justice and reparation and memory. And one of the key concepts in human rights is the concept of violation. So how do you translate what is the concept of violation in Kekchi? And during ethno-linguistic workshops and conversations with elders, etc., the concept in Kekchi is mushuk. And what is really interesting, if you start to explore the several semantic fields of that verb, mushuk, then you already see that it goes indeed beyond the human, what happened during the war. Mushuk also referred to the Tzultaka, the violation of the Tzultaka, the violation of the sacred corn. Mushuk also means, well, from a legal perspective, you can translate it into violation, but it's actually profanation. It's desecration of something which has dignity, of something which is sacred. So in 2014, I went back to the same region, because in the same region in Guatemala, that region was threatened by the construction of the second biggest dam in Guatemala, called the Shalala Dam. And I was asked to do a policy research about the possible human rights impacts of the construction of such a dam on the territory of the Maya Kekchi, who were already survivors of the genocide, and most of them internally displaced people. And when I listened again to the elders in Kekchi, then I heard the same expressions coming up, that the river would be violated. Actually, the expression is shmushbal, which is from the verb mushuk. Kiuam is life. Nimlaha is the big river, is the river. So the construction of such a huge dam, from their perspective, would actually kill the life of the river, because the river is the mother, the side rivers are the children, the fertile fields around the river is a father. So it is a family, it is a big family alive, and it will be killed through the destruction of that dam. So connecting these narratives with the human rights framework and with, for example, the human rights to water, yeah, that was quite challenging because the human rights to water, for those who are familiar with that framework, know that it's a very technical right, which actually narrows down water to a commodity, and that we need to have access to that resource. So there you see a very huge clash and tension between indigenous perception of what is water and how it has been conceptualized within the human rights framework. So the key research question of rivers is, to what extent can international human rights law come to grips with purely legal water realities? And this is the river we are talking about, the Chicxoy River in Guatemala, that would be dammed by that huge dam. And that would affect almost 220. So this is a research design of the project. I'm not going in too much details now. If you're interested, we have our website where you can find much more details about the 2 streams, the work packages. But let's say that the idea is, after 5 years, to come with new empirical data to respond the big question about water, human rights beyond the human. We work at the local level in 3 countries, in Nepal, Guatemala, and Colombia. And then in Research Stream 2, we are focusing more on the UN level. So this just to have a bit of an idea about what we are trying to do. And so based on my own research, the Rivers Project wants to create those empirical dialogues based on legal anthropological research in those case study countries and also within the UN, and to contribute to several debates within international law. One is human rights and cultural pluralism. The other one is what Peter already mentioned, decolonizing human rights, and also to the debate in social science about the ontological term. So this is a bit the setup of the project. And looking into these questions, which are really urgent these days, more than ever, about our relationship, human with nature, and looking from it from a law lens, then I see that there is a jungle of legal concepts and frameworks. I have tried to make a brief list of what is currently circulating in the law field. So you have, of course, the more traditional field of environmental law, who use the concept of environment. Also, there is more an ecosystem or ecosystemological turn in environmental law. You have the concept of wild law. You have now the emerging human rights to a healthy and sustainable environment. For example, we have the UN Special Rapporteur on human rights and the environment, who is pushing forward this line. Another concept which is circulating is earth law, connected with earth jurisprudence. We have the concepts of rights of Mother Earth, Pachamama. If we think, for example, to the constitutions of Ecuador and Bolivia, there's also a proposal circulating worldwide to create a universal declaration of the rights of Mother Earth. Then we have the concept as such of rights of nature, and nature with a capital, not with a small n. We have the river rights. Actually, when I was drafting this ERC project in 2017, some of you might know that in that year there were a couple of countries spread over the world who granted rights to rivers. The first one who got into the news, let's say, was New Zealand. And then a couple of weeks later, there was a high court in India that granted rights to the Ganga River. And then I think a month later, Colombia, the Constitutional Court of Colombia, granted rights to the Atrato River. And the Indian High Court and the Colombian Constitutional Court made actually reference to the law in New Zealand, who granted rights to the river in New Zealand. And also these days there is a proposal of a universal declaration of rights of rivers circulating too. Then when it comes to indigenous people rights, we have already the collective rights of indigenous peoples to land, territory, and natural resources, which are enshrined in the ILO Convention 169 and the UN Declaration of 2007, the rights of indigenous peoples. I recently learned that there is also a rights of landscape, that there is a literature body discussing rights of landscape. You have the concept of biocultural rights, then you have animal rights, and very recently, the special jurisdiction in Colombia, which is the court system that was created as part of the peace agreements, recognized territory as victim of the Colombian armed conflict. And when you go through those literature bodies, then you see quite a lot of debates about anthropocentrism, ecocentrism, biocentrism. So it seems that within law that we are quite struggling with the relationship from nature, environment, ecosystem, Mother Earth, animals, etc. And yeah, the big question is, I think, where are we going with all those concepts and with all those research proposals and those legal new frameworks? So today I wanted to focus a bit on what I've been calling the rights of nature hype. Here a couple of researchers have been labeling this hype actually as a social movement, as a transnational policy network, and even a new epistemic community within the law field, which celebrates rights of nature as something universal but non-Western truth. So as the, let's say, a very critical reading of the environmental law. In the paper that I'm now wrapping up, I use a concept of Molle, who created that idea of a nirvana concept within the water field. And it seems that this rights of nature emerging framework is seen by many people in the law field as the new, well, response or counter-hegemonic answer to the human-induced environmental degradation and the impact of the Anthropocene on our planet. But as Molle writes, we have to be a bit careful. Now this nirvana concept of rights of nature is snowballing around other nirvana concepts. I do believe that it is important at this moment that we need to take a step back to observe and create a space for deep reflection. Because as Molle has shown, when it comes to this kind of nirvana concept that's spreading all over the world, then there is a risk that descending trends might be suppressed and that rights of nature will be accepted without even being questioned, thus turning into a truly hegemonic discourse, while proponents of the rights of nature movement or concept are actually seeing it as a counter-hegemonic discourse. And from my perspective, I think we also can start talking about that rights of nature as an emerging transnational legal framework. I just put today this picture because 2 or 3 days ago in Europe, this document or this study was released, and it is a proposal to create a European Union Charter of the Fundamental Rights of Nature. So when it comes to rights of nature, it might be interesting to look at one of those important proponents of this rights of nature proposal, which is the Global Alliance for Rights of Nature, who defines rights of nature as a recognition and the honoring that nature has rights. It is a recognition that our ecosystems, including trees, oceans, animals, mountains, have rights, such as human beings have rights. And they propose it as a holistic recognition. that all life, all ecosystems on our planet are deeply intertwined. And it's very interesting if you think from an international legal perspective. For example, since 10 years, the UN is celebrating on the 22nd of April, the International Mother Earth Day. And this year, the president of the UN General Assembly actually called that day that Mother Earth should be preserved, a paradigm shift from a human-centric society to an Earth-centered global system, which is a very intriguing proposal, certainly if it comes from the president from the UN General Assembly. And since 10 years, there exists a UN program, Harmony with Nature. I'm also part as an expert of that network. Every year they write a report, and this report of 2020 is extremely interesting if you're interested to see where that human rights of nature snowball effect is hovering around the world, because they have listed up all the countries with new and emerging the legislation and policies. And this report actually talks about a mosaic of Earth-centered law. And according to the database of this program, which I really recommend to have a look at, there are already 35 countries in the world who have kind of legislation and policies regarding rights of nature, earth jurisprudence, earth law. But one of the things that I am a bit concerned about is what we can see as an indigenous term in this proposal of rights of nature, or how we look from a legal perspective to environment, territory, and so on. And as you will see, and the many events, mainly online now, which are being organized to discuss rights of nature, you will see and notice that many times proponents of rights of nature are saying that rights of nature, its fundamentals come from indigenous thinking and indigenous practice, and their relationship with nature, with earth. So here I quote a couple of researchers, and who talk indeed as scaling up of those local norms towards a global level, and that rights of nature is opposing commodification of life and the anthropocentric dualism of Western thought. However, it's interesting, I think, to mention that it's not the first time that within Western legal theory and practice there is a kind of an indigenous term. My first degree is in criminology, long time ago, and I was student when there was this emerging paradigm shift towards restorative justice. So people who work in the criminal law and are familiar with the restorative justice paradigm know that the basis and the fundamentals are also come from indigenous practices when it comes to the mediation, victim-perpetrator relations, and so on. And the people who have been working on transitional justice, just as me back then, almost 20 years ago, know that at certain point there was a huge debate in the African continent about the mobilization of traditional justice as another tool of the transitional justice toolbox. So now it seems that within environmental law, there is also this turn to indigenous thinking by tying up mainly Latin American narratives of indigenous peoples' life and nature with this legal proposal and new legal concept of rights of nature. Though at this point, at the moment of snowballing, and that I invite a bit to pause and to break and to have a bit more critical reflection, in a paper I have described a couple of risks that I see when we tap into indigenous knowledge about nature and environment as one of the fundamental bases. And at the same time, they have many questions which in my opinion have not been sufficiently addressed by Euro-American trained legal scholars who are promoting this rights of nature. And here, for looking a bit into the time, I only want to share three points or three risks regarding that. And one is if there is a risk that rights of nature comes as a competitor to indigenous people rights when it comes to defending indigenous people's territories and right to land. As you might know, indigenous peoples have struggled a lot to get their collective rights recognized within the international human rights framework. So we have a couple of binding and more soft law tools. There's a huge jurisprudence, for example, in the Inter-American Court of Human Rights produced, protecting the right to territory, land and natural resources of indigenous peoples. But now there are a lot of cases where rights to rivers are recognized within indigenous territories. And there, in a conversation with the former UN Special Rapporteur of the Rights of Indigenous Peoples, Vicky Tolu-Corpus, she expressed her concerns. To what extent this new legal concept of rights of nature and rights of rivers might actually suppress and even compete and even sideline the rights of indigenous peoples to territory. Because in the international human rights standards, indigenous peoples have the collective right to territory, and territory there is already recognized as a holistic concept that indigenous peoples have multiple relationships and dimensions with their land and what is called natural resources. A second risk or concern that I have, and here we come into the ontological questions, is the risk of essentializing and codifying indigenous nature ontologies. And why? Well, when I was doing that study or working with the Kikchi indigenous peoples in Guatemala, regarding the war, regarding the impact of that dam, what I learned there is that if the dignity of the river and the dignity of the sacred mountain is not respected, as a living being, they will react. They can get angry. For example, when I was last time in the same region in 2018, there was a drought in the region, and we had several ethno-linguistic workshops with elders and with youth about that impact on their territory. And it was very, very interesting to learn that according to the elders, the drought and the fact that that river was withdrawing, was actually drying out, was to them not only because of the pollution, because of cutting down the trees around the spring of that river, but because the river was angry. And yeah, to put it in a very blunt way, the river was fed up of the people around itself and was angry and withdrew itself. Having the same conversation with indigenous youth in that region, they give the explanation about the contamination, about destroying the forest, etc. But they did not make that ontological leap, to put it like that, towards the fact that the river is a living being, that we didn't respect it, and that's why it was angry and withdraw itself and dry up. So from a legal perspective, when we grant rights to rivers supposedly based on indigenous practices, what about rivers that get angry or mountains that start to tremble because of the human behavior that affects negatively the rivers and the mountains. I'm really interested to hear legal thoughts about that. Of course, we could narrow those narratives of those indigenous elders towards beliefs, that it is just a belief and as a cultural interpretation of what they see as a river, or, and that's the invitation that anthropologies do more and more towards the ontological turn, is to recognize that there are a pre-verse of worlds, that there are different ways of viewing the world, that there are different existing worlds, and one of these existing worlds is, well, indigenous peoples. For example, the Kikchi are saying that rivers are indeed living beings, but that also need to be respected, or otherwise they can cry, they get angry, and they react upon us. And obviously, when it comes to essentializing and codifying indigenous ontologies, this is not so new. If we look into to legal anthropological research and also the litigations of indigenous people's rights, then there is quite a broad discussion about how indigenous peoples make political claims by going to court, and that there is a strategy of essentializing. That's actually Spivak who first coined the term of strategic essentialization. For example, from indigenous claims about authority, about natural resources, etc. And as I mentioned, indeed, if you participate in many of the international seminars about rights of nature, then you will see the participation of indigenous peoples. A very interesting research done is in Ecuador, for example, recognized that at the end, indigenous peoples have used the springboard of rights of nature to bring their claims about the destruction of their territories by mining, by hydroelectric dams, towards the political and legal sphere by jumping onto that international hype now of rights of nature. And I'm looking into the time. I wanted to end with a final reflection, a bit tying everything a bit together, and looking into the decolonization of human rights. And here, I think it's very important. And that's one of the things that I would love to see more in the debates going on about rights of nature, as it is seen and proposed as a counter-hegemonic legal framework towards environmental law. And the big critique to environmental law is that it sees nature and environment as a property, and as, for example, water and land as a natural resource. But at this moment of snowballing and the nirvana concept of rights of nature, I think we still have to make a critical reflection that historically international law exhibits, and here I quote Fukurai, which is a legal scholar, a Japanese legal scholar based in the US, that international law has exhibits always predatory behavior, resulting in what he calls a destructive legal imperialism. And another reflection which calls a lot to me is a reflection made by the indigenous Maori scholar Tuai Smith in her very landmark book of '99 about the decolonization of research methods from an indigenous perspective. And I would like to draw on her reflection in general towards social science and to transplant it to the field of international law by recognizing this field of international law as a significant side of struggle between interest and way of knowing the West and the interest and way of of the others. And to end this presentation, the last couple of years I had the opportunity to collaborate with an Indigenous judge who is a judge within the special jurisdiction of peace in Colombia, the one which I mentioned before, who has recognized last year territory as a victim, which obviously raises many questions, certainly from a transitional justice perspective, because this means that victim is not only the human, but also territory. And she always invites me to, when we have these discussions about our relationship with territory, with nature, with environment, with ecosystem, to go back to the origin and to reflect. And this is very similar to what the Mexican anthropologist also calls to us as researchers, anthropologists, but I would like to extend this call also to Western Euro-American legal trained scholars, is to critically analyze our own conceptions and to learn to listen and to understand the experiences of local protagonists who participate in all those processes that we actually are facilitating, not only as researchers, but also as scholars, as researchers, and as activists or as legal lawyers, or as lawyers, to put it this way. So this was a bit a couple of points or reflections that I wanted to share with you, and I'm really looking forward to hear your thoughts, to hear your feedback, even questions. Certainly, as this moment of the project that we are delving deeper in the main research questions and in the different work packages. So yeah, I would like to leave it here. Thank you.
Thank you very much, Lieselotte. Declan, can you invite people in if use the hand icon? Is Declan still? Okay, I'll just invite you to offer some observations or a question to Lieselotte. Is there anybody who would like to this stage? Okay, I see someone with the initials BS.
Yes, that's
Brigitte, yeah.
Thanks, Peter. Thanks, Lieselotte. That was very enjoyable. I'm not a lawyer. My background is in political theory, but I'm very interested in questions of ontology and in this whole concept of the more than human. And I'm just wondering how you see the connection between, you talked about essentializing Indigenous ontologies, and I can see how this translates, or how this can translate very easily into law. But the way I understand more than human ontologies is in a more sort of more plural, more fluid way. And I wonder whether these more than human ontologies always escape or exceed the limits that are imposed upon them by the law. And perhaps I'm reading the law wrongly, but I'm just wondering if you can maybe share your thoughts on it, because I know similar debates are happening in the field of animal rights discussion and the whole tension between a kind of non-anthropocentric ethics and on the one hand, and the debate on rights and justice on the other hand.
Mm-hmm. Thank you for your very important question. What do you propose, Peter, that we take a couple of questions, or prefer that I reply one by one, or what would be?
If I could just invite guests to use the little hand icon if you would like to come into the conversation, and then I'll call you in. And for the moment, we'll invite Lieselotte to respond to Birgit's question. Thanks.
Yeah, thank you. Indeed, I didn't, well, I wanted to, let's say that the whole debate about ontologies and law can be a seminar as such. And actually, the last 2 months in my team, we have very interesting debates and conversations. So I have a very interdisciplinary team of lawyers and also anthropologists. And we were actually reading a couple of those introductions and basic texts about the ontological turn from an anthropological point of view, and then connecting so with legal topics. Indeed, there is one thing is that when you go into the litigation, that what other legal anthropologists have already analyzed is that there is that essentializing of certain concept, etc., to make the point across, to put it like that. That there's a very interesting literature body on Buen Vivir on the concept of good living and summa causae, and how that concept actually was created and constructed as a counter narrative towards development. I do think that it goes indeed much deeper. I would like to refer to what I briefly mentioned when I did my research on transitional justice among the Quechua in Guatemala 15-20 years back ago. And to make it very concrete, for example, Guatemala created a national reparation program to repair the wounds, to heal the wounds of the conflict. There was a very administrative preparation program. And what happened, for example, is that when people had to request economic reparation, because that was one of the measures, they had to demonstrate how their was killed. And within the Quechua, and which is very common in Mesoamerican indigenous communities, is that you can die because of losing your energies or your spirits, to put it like that, which calls in Spanish is susto. And that happened a lot because a lot of that region, people fled into the mountains, survived months and years in the mountains, and people died, not because of the massacres, not because they were killed by the army, not because of hunger, but because of losing that energy, and they just died. At the moment of requesting economic compensation, because from their perspective, they died because of the war, obviously that was not recognized at that moment, because within law, even within Western psychology, you can't die because you lose your spirit. So at the community level, you had quite a lot of tensions, because you had families who received the economic compensation because they could prove that their family members were killed. And then other families who did not receive the economic compensation because they could not legally prove what was in their worldview a truth. They died because they lost their spirit, and they lost their spirit because they were afraid, because of the bombing, because of everything that happened in the mountains. And there you see that tension between worlds. In one world, it does exist, while in another world, it simply does not exist. It's the same. If I make quicker a connection so with the debates now in Colombia about the fact that the territory is recognized as a victim, when it comes to litigation, obviously one of the questions is the same as in the debate of rights of rivers. So who's going to talk for the territory in court? And there you have the tension about, again, legal knowledge. In many indigenous communities, the people who have the knowledge about the suffering and the well-being of a river, of a mountain, or whatever, is not the political authorities, but it's the spiritual guide, it's the shaman, it's the elder, and that knowledge, for example, can come through dreams. Or for example, they read a fire ceremony, and there in this fire ceremony, they receive the message, for example, of the river who is threatened by a hydroelectric dam, that it is afraid that it will die. That kind of knowledge in court case is not up to date, recognized as knowledge. There you have a whole debate about ontologies and epistemologies and who produce knowledge and who decides what is knowledge. But knowledge based on other worldviews and other ontologies. So I don't know if this replies more or less on your concern and clarifies a bit on the practical level when it comes to different ontologies in law.
Birgit, would you like to come back in there, or are you happy with that?
Yeah, thanks very much for that. Yes, thank you.
Okay. When you see a proliferation of concepts, you talk about that snowball effect, Lieselotte. I always think it's useful, and I think this is what you're doing in any case. It's useful to go back and say, look, if these are the responses or the answers to a question, and they're taking different forms, no doubt influenced by different power perspectives and different ontological assumptions. But if these are the responses, what is the deep fundamental question that's driving and provoking that proliferation of divergent responses from your perspective? And would you offer an answer that, I suppose, includes a reference to power and ontology?
Thank you, Peter. I think we can have a long conversation about that. I find it very intriguing how, from a law perspective, indeed, there are all those different concepts, and one is taking height now, that's the one of rights of nature. While there are also others, although it's mixed with Mother Earth and then Earth jurisprudence. I think that I would like to see it more as a kind of an invitation for us to and that's what I said or tried to explain at the end of my presentation. No, is to think about how were those concepts actually created? Like environmental law starts from seeing nature as property, and I think many studies are demonstrating that how environmental law has been created and all the policies and governing systems is not giving the results that we would like to see. So I think it is a bit at this moment that we are facing in the world with climate change, with the pandemic, I would like to see it as really an invitation to go really deep and think about our Western European American legal assumptions and how actually thinking about reflecting on authors that come from the decolonial theory and to start recognizing that these conceptions of seeing everything as a property and to protect something outside ourselves and not part of it, that this is part of that provincializing our Western European thinking to something the universal, which actually it's not, and that we need to open up space for much more dialogue with knowledges and ontologies that historically has been discriminated, neglected, perceived as belief, and not as something that could be could be true. And the other one is obviously the whole debate about the pluriverse of worlds and the existence of many worlds, which can be very frightening for many people. But I think at this moment we need to go deep and to delve deep, like we did the last year, which I think requires a lot of dialogue and a lot of listening from our side. And I just showed like a Western within how do you say that? It's not brackets. Well, also to recognize that there is not such a thing. I think that could be a trap to see the Western and the rest, or the rest against the Western. I am a bit, and that's one of the critical reflections towards rights of nature, that it's now seeing as the answer of non-Western truth. But at the same time, the concept of legal personhood, is that not very colonial Western concept? And right concept as such, it's just questions that I'm just throwing out. The concept of right as such, is that not a very coming from Western thinking about how to relate and how to organize things? And the answer is no. I don't have a clear-cut answer yet. I'm still struggling with a lot of things. I think we all do. And I think it would be great to connect with other people who have the same struggles, and to have this kind of more critical debates. And hopefully, well, in the next years with the Rivers Project, we can open a path of more critical reflections and more deep reflections.
Okay, thank you very much, Lieselotte. I'm just keeping an eye, and I don't see any other questions or interventions as we come up on the hour. Is there anybody else who would like to come in at this point? While we're giving 30 seconds for that, may I ask you, Lieselotte, would you be happy to share your slides? If could you send your slides to us, and we'll circulate them to those who signed up for this afternoon session?
Yeah, I think it's not a problem. Maybe I will wait until the papers are published. Or I don't know. That's always. Obviously, there is a lot. What I have just shared is actually already a bit available on the Rivers website. I wrote a couple of blogs. We did a lot of seminars. Like last year, we launched the project, and we had a very interesting seminar. And if you're interested, you can go to the YouTube channel. We had a launch with the participation of the now former Special Rapporteur of Indigenous People Rights, also the chair of the Permanent Forum. We had the Indigenous Judge Belkis Izquierdo from Colombia among us, also an anthropologist from Nepal, where we discussed a bit the main research questions of the Rivers Project. A lot of those topics came already up. So there you can find very interesting material, I think.
Okay, well, on behalf of everybody who has taken part, thank you very much for your presentation. We do look forward to seeing you in person, maybe at a later stage in your investigation. I think you're raising really essential questions, so thank you for doing that. We look forward to hearing from you again. And thanks to everybody for your participation. And thank you, Declan.
Yeah, thank you, Peter, for creating this space, and also to the Human Rights Centre of Queen's, the University of Belfast. And I hope that we can continue in this dialogue that we started like a year ago, maybe in any near future, other conversations about these topics. And you can always write to me if some of the participants feel more comfortable to write me personally. I'm happy to hear your thoughts and your reflections about what we discussed today.
Okay, that's very kind of you. Thank you very much, everyone. Thank you, Lieselotte. Okay.
Thank you.
Bye-bye.
Bye.